Bismillahirrahmanirrahim. Section 6. Not later than 30 days after the answer is filed, the case shall be calendared for pre-trial should the parties fail to arrive at an amicable settlement. Should the court shall clarify and define the issue of the case, which shall be set forth in a pre-trial order. Section 6, number 2. Within 10 days from receipt of such order, the parties or counsel shall forthwith submit to the court the statement of witnesses, shuhud, and other evidence baina pertinent to the issues so clarified and defined, together with the memoranda setting forth the laws and the fact relied upon by them. Section 6, number 3. Should the court find, upon consideration of the pleadings, evidence, and memoranda, that a judgment may be rendered without need a formal hearing, the court may do so within 15 days from the submission of the cases for decision. Section 7. Hearing or trial. The plaintiff Muda'i has the burden of proof and taking of an oath yamin rests upon the defendant Muda'i alay. If the plaintiff has no evidence to prove his claim, the defendant shall take an oath and judgment shall be rendered in his favor. Should the plaintiff refuse to affirm his claim under oath, the case shall be dismissed. Bismillahirrahmanirrahim. Section 7, number 3. If the defendant desires to offer defense, the party against whom judgment will be given on the pleadings and admonition made, if no evidence was submitted, shall have the burden to prove his case. The statement submitted by the parties at the pre-trial shall constitute at the pre-trial shall continue the direct testimony of the witness as for cross-examination. Section 7, number 3. If the defendant desires to offer defense, the party against whom judgment will be given on the pleadings and admonition made, if no evidence was submitted, shall have the burden to prove his case. The statement submitted by the parties at the pre-trial shall constituted at the pre-trial shall continue the direct testimony of the witness as for cross-examination. Section 8. Judgment. The judgment shall be rendered within 15 days from the termination of the trial or disposition of the case, should there be no formal trial or hearing. Section 8. Number 2. The judgment and shall become final and executory upon the expiration of the period to appeal. Once the judgment becomes final and the court motu proprio shall immediately issue the writ of execution for the satisfaction of the judgment. Section 9. Appeals. An appeal shall be made by filing a notice of appeal addressed to the court and by paying the docket fee within 15 days from receipt of judgment. Section 10. Appeal to the Sharia District Court within 5 days from perfection of the appeal. The clerk of court shall transmit the original record to the appropriate appellate court. Section 11. Appeal to the Supreme Court. Upon receipt of the original court transcript and exhibit of the clerk of court of the Sharia District Court shall notify the parties as fact. Section 12. Legal opinion fatwa. Before judgment is rendered, any court may seek the opinion fatwa of the jurisconsult of Islamic laws created under the Code of Muslims, personnel laws, and matters concerning difficult questions of Muslim laws and jurisprudence speak. Section 13. Pleadings and motion disallowed. The court shall not allow the filing of the following pleading, petition, or motion, namely: letter A. Motion to dismiss or to quash. Letter B. Motion for a bill of particulars. Letter C. Motion for extension of time to file pleadings or other papers. Letter D. Motion to declare defendant and default. Letter E. Reply third-party complaints or intervention. Letter F. Petition for certiorari mandamus or prohibition against any interlocutory order issued by the court. Letter G. Petition for relief from judgment. Letter H. Motion for new trial or reopening of trial. And letter I. Any dilatory motion for postponement. Bismillahirrahmanirrahim. Section 14. Administration of oath. An oath means legally binding in a manner and form observed under Muslim law may by order of the court be administered upon any of the parties who are Muslim to establish fact or to affirm any evidence presented. Such oath may constitute as proof in the absence of any other evidence. Section 14. Second, no person shall be allowed to take an oath unless he is qualified under Muslim law and is fully aware of the solemnity of the oath or the import of the oath or solemn affirmation in accordance with Muslim law shall be given reasonable time to think it over. Number 3. The court shall set an appropriate time, date, and place of oath taking or of solemn affirmation by such person at any time before such appointed date. The party who is required to take an oath or a solemn affirmation refuses to do so, the court may, in its discretion, direct the person, if he is the plaintiff, to withdraw his claim, or in case of the defendant, to admit the claim of the plaintiff. Section 15. Mutual of Tahalluf. In case of claims and counterclaims where neither of the parties would give way at the pre-trial, the court may, in its discretion, require both parties' mutual oath tahalluf on any particular fact or fact upon which the court may render judgment. Rahim Section 16 Mutual Imprecation Lian. If a Muslim husband accuses his wife of adultery and fails to prove the same in accordance with Muslim law, the court may require the husband and the wife, if she is a Muslim, to perform the prescribed act of imprecation lian, and thereafter the court shall dissolve the marriage by issuing the appropriate divorce decree and in accordance with the provision of the Code of Muslim Personal Laws. Rahim. Section 17 Supplemental Rule and Civil Cases Muslim Laws on Evidence. The court shall adhere to the sources of Muslim relating to the number, status, or quality of witnesses, adala, and evidence required to prove any fact except as her and provided the rules of court shall apply in a supplementary manner. Section 18 Supplementary Rule and Special Offenses. Subject to the next precedent sections, all special cases or offenses cognizable by the court may be filed in such form and hid in such manner as prescribed by the applicable laws and the rule of court. However, the court may apply in a supplementary manner the principle of Muslim laws. 19. Agama arbitration. How conducted? The Agama Arbitration Council, after its constitution pursuant to the provisions of the Code of Muslim Personal Laws, shall conduct the arbitration proceedings in accordance with the method it deems appropriate, taking into consideration the circumstances of the dispute, the conciliation of the parties, the interest of children, if any, and the other parties involved, and the need for a speedy settlement of the dispute. However, no arbitration proceeding shall take place part. Section 20 Effectivity. These special rules of procedure take effect immediately, approved unanimously on September 20, 1983.